Hello, and thank you for joining me for the first part of our IP talk on digital health, in which I'll be providing some practical advice on identifying and patenting digital health inventions. My name is Jack Severs. I'm a UK and European patent attorney at Gill Jennings Every. GJE are a specialist IP law firm with our main office here in London, and we advise a wide range of clients on patents, trademarks, and design rights. I lead GJ's MedTech Business Development Group, and so a significant part of my time is spent advising health tech companies at all stages. My aim for this talk is to provide some practical advice which reflects the questions that arise most often around patent protection. So we're clearly going through a period of rapid innovation at the moment in healthcare. We're seeing a large number of companies increasingly applying the latest computer technologies to address some of the pressing issues in healthcare. These include an increasing aging population, improving access to healthcare, trying to address the vast amount of resources which are spent on managing chronic conditions, better collecting and utilising the vast and messy data sets produced by the health service, and tackling the problems associated with global issues such as climate change, pollution, and pandemics. So this innovation is reflected in a large number of patents being filed in this area. The graph on the left shows the patents filed at the European Patent Office in 2019 and shows that medical technology actually fell for the first time in 10 years to second place behind digital communications in terms of the sectors in which most patent applications are filed. So this was partly due to a large rise in applications for digital communication and computer technology. And that trend was actually reflected within the patent filings for medical technology. The graph on the right is taken from a report that we put out recently that you can find on our website, in which we looked at the patent filings across medtech. And it showed that those sectors relating to digital health had shown a huge growth in patent applications over the last few years. So you can see that applications relating to wearables, intelligence, software have all increased rapidly over the last few years. However, my experience from advising health tech companies is that there are still quite a few misconceptions around the patent process. The questions that I get asked most often are around patentability, so whether a particular digital health technology is patentable, and secondly, whether patent protection is the right option. So over the three parts of this talk, I will be addressing these most frequently asked questions. So to answer the first question, I'll explain the definition I'm using for digital health. I'll then give a summary of the key features of how the European Patent Office assesses patentability of digital health inventions. I've then chosen a number of example technologies which I think reflect the categories of technology which we see most often. And I will show you how to apply the European Patent Office's approach to those example technologies to hopefully provide you with some practical guidance on how you can assess your own digital health technology. To consider whether patent protection is the right option, we'll firstly look at the benefits of patent protection. But we'll then explore an alternative route, which is particularly relevant to software inventions. And that's whether you could instead keep aspects of the technology confidential rather than filing a patent application. We'll look at the considerations that you need to weigh up in making that decision. And again, I'll use one of the example technologies and apply those considerations to show you how to determine whether patent protection is the right option. So firstly, what do we mean by digital health? Well, there are lots of different definitions out there. Most of them center on this quote at the top of the slide: the convergence of digital technologies with healthcare, with the aim of enhancing the efficiency of healthcare delivery and making medicine more personalised and precise. For the purposes of this talk, I'm going to use a simplified definition, which is simply any technology with software or computer implemented aspects, which is directed at health applications. So I'm basically just distinguishing from conventional medical devices, your stents, catheters, syringes, and focusing on any health technology which includes software or computer implemented components. So this is an exhaustive list, but these are some of the categories which I think reflect those technologies which we see most often. So firstly, there are a large number of companies out there providing software platforms which are directed at connecting patients, various types of clinicians and carers to allow for the sharing of information and the provision of healthcare more efficiently and providing greater access to healthcare. A second category relates again to software platforms, but this time for automatic diagnosis. So there are a large number of platforms which support primary healthcare, like Babylon Health. There's also a lot of more specific platforms now looking at specific conditions and providing screening for those conditions. The next category is closer to more conventional medical devices and relates to any kind of medical device which has some kind of software control or where the software takes as input some data from some hardware of the medical device. Finally, there's obviously a huge amount of innovation around the analysis of patient data. So particularly the rise of learning being applied to analyze image, voice, and other types of physiological data. So the examples that I'll be using later generally represent these categories. So to answer this first question, is my digital health technology patentable? We firstly need to understand a bit more about how the Patent Office approaches analysing the patentability of digital health technology. So I'm not going to get into the specifics of the legal tests involved here. We have a number of talks on our YouTube channels which go into more detail, particularly the talks on computer implemented inventions and machine learning will provide a lot more detail on the specifics of the legal tests. What I want to do is provide some practical advice which summarizes the most relevant points, particularly in the context of digital health. So ultimately, digital health technology is assessed as a computer implemented invention, but it firstly must meet the requirements of any other invention. It must firstly be novel, new. So this is a fairly low hurdle to meet. It basically means that there must be at least one difference in the technology from the closest technology that is already known. And by known, we mean any technology which has been disclosed anywhere around the world. The second requirement is that it must be inventive. This is a slightly more difficult hurdle to meet. It basically means that those differences from the closest technology must solve some kind of problem in a non-obvious way. And during the live version of this talk, we had a useful question, which is how much difference is actually needed? Well, this is assessed through what the Patent Office refers to as the skilled person. Basically, a person who is aware of the closest technologies in the field. They're aware of what's already been disclosed, but they have no inventive capability whatsoever themselves. So it is basically a question of whether the prior art leads inevitably to your technology, or whether you can argue that there's been some kind of inventive leap which you've had to make in order to solve the problem. My advice is always, if you've had to overcome some kind of problem in the field, some kind of technical problem, then that's a very good indicator that there may well be an inventive step. But there's a final category which your technology must meet in order to be considered patentable. and that's that it must be considered technical. That is, the contribution of the invention, i.e. the problem solved, must be within a technical field. So what is considered technical? Well, the Patent Office doesn't provide any kind of single closed definition on what they consider technical. Instead, what they provide are a series of rules in the law defining general areas that are not considered technical. So categories of subject matter which are excluded from patentability. They also provide specific examples of inventions that are considered technical. So generally these relate to where a patent application has been filed for a technology which is near the bounds of one of the general areas of point 1. And the Patent Office has had to decide whether that is technical or not. And so we have case law providing a series of specific examples of inventions that are considered technical. So to check whether your technology is technical, we need to consider whether your invention, i.e. the problem solved by your invention, falls outside of one, so outside of those general areas, or ideally you want to show that it falls close to one of the specific examples of point 2. So I'm now going to go through and explain some of those general areas and some of the specific examples. So the law sets out a number of areas that are excluded from patent protection. I'm not going to go into the full list here, but you can find a full description on our talk on the introduction to patents on our YouTube channel. I've selected some categories that I've seen come up regularly in respect of digital health inventions. And so if the problem solved by your invention falls solely within one of these categories, then it will not be considered technical. So the first category is fairly straightforward and it relates to the presentation of information. So if you come up with a new health app, it might be the first health app ever to provide information on a specific condition, but the only difference from the existing apps that are out there are really the type of information that is provided and the way that information is displayed, then that will not be considered technical because all of those new features relate solely to the presentation of information. A second important category is administrative procedures and methods of performing a mental act. What that means is if you have developed an app which simply automates a mental process or an administrative procedure, then that will not provide technical merit to the invention. So for example, if you've developed a platform that receives answers to a patient questionnaire and provides a personalized treatment plan in response, that process is something that would happen with the clinician. They would take your information, so height, age, weight, and provide a treatment plan which is suitable. Simply taking that process and putting it in the form of an app is not going to provide any technical merit to the invention. A very important category relates to mathematical methods, so algorithms and programs for computers. This is where a lot of the confusion comes in around software. Although the law states that programs for computers and mathematical methods are excluded, this is only where the technology relates solely to those features. If there is a link to a further technical effect, particularly to a technical application, so a healthcare application, then they will be considered patentable. So where I see this come in is where a company has tried to go too broad with their claims and they've tried to claim a mathematical method or a programs for a computer broadly, which is applied to abstract or undefined data. So you really need to link the model, the software into a specific application, and then it will be considered technical. The final category relates to methods of treatment or diagnosis performed on the human body. So the reasoning behind this is that a clinician, a doctor, shouldn't be restricted from treating a patient by the existence of a patent. In fact, this is actually very easy to overcome. If you have any kind of device which implements those features, or if you provide a device for use in such a method, it will not fall into this category. But where I've seen it come up is actually where a company, what they've developed really relates to a new method of treatment. They may be providing it through an app, but the new features relate solely to a method of treatment. So for example, I spoke to a company that had come up with a new exercise regime for injury recovery, which they were providing through an app. But the thing they wanted to protect really was that they'd come up with this new regime for injury recovery, and that would not be considered technical or capable of patent protection. So those are the broad areas defined by law as being excluded from patent protection. More positively, the European Patent Office provides a number of examples relating to digital health applications which are considered technical. In fact, it looked very favorably on health tech and med tech applications. So these are each examples taken straight from the EPO's guidelines for examination of applications which are considered technical. So if you can find parallels between your technology and one of these examples, that's a really good indication that it will be considered technical and capable of patent protection. So the first relates to software for controlling a specific technical system or process, for example, an X-ray apparatus. Another example is providing a medical diagnosis by an automated system processing physiological measurements. Obviously, that's quite a broad example. So any kind of diagnosis tool where you process physiological patient data will be considered technical. The next couple of examples relate to machine learning. So the use of a neural network in a heart monitoring apparatus for the purpose of identifying irregular heartbeats, classification of digital images, video, audio, or speech signals, which could clearly relate to patient data based on low-level features. Both of those are examples of what are pure mathematical method features, but because they have a technical application in healthcare, they would be considered technical. I should say that, of course, these aren't limited. Some of these examples are quite specific. So if we look at the last example, deriving the body temperature of a subject from data obtained from an ear temperature detector, clearly any technology which has parallels with that, so deriving another patient parameter from data obtained from a sensor, will also be considered technical. So if you can find a parallel between the problem you're solving with your technology and one of these examples, then that is a very good indication that it will be considered technical and therefore patentable. So that concludes the first of the 3 sections of this talk on patenting digital health inventions. You can find the other 2 parts on our YouTube channel. If you'd like to find out more about IP and how to protect your innovation more generally, you can find information on our website. If you have any more specific questions, then please do feel free to email me at jack.severs@gje.com, or you can connect with me on LinkedIn and I would be happy to answer any questions that you have. Thanks for listening.